What happens if you're partially at fault in a car crash? Can you still recover compensation for your injuries? Probably, but it's a little more complicated than that. In this video, I'll explain how Louisiana's comparative fault law works, major changes to the law, and what you need to do to protect your claim if you share any blame for the collision. Hey, I'm attorney Lloyd Bourgeois, your Louisiana injury attorney. I spent years helping injured people fight back when insurance companies try to take advantage of them. If you've been in a crash and need someone in your corner, give me and my team a call today at 504-882-9867 for your free case consultation. Remember, when you want to win, you gotta give them the L. Let's clear something up right away. Being partially at fault doesn't automatically disqualify you from recovering compensation here in Louisiana. But how much you can recover, and whether you can recover at all, is about to change in a big way. Understanding the difference between the current law and the new law starting right now in 2026 can mean the difference between getting paid and getting nothing. So Louisiana currently follows what's called pure comparative fault. It's one of the most fair systems in the country for car crash victims. Under pure comparative fault, you can still recover compensation even if you were mostly at fault for the crash. Your damages just get reduced by your percentage of responsibility. Here's how it works. Let's say you're in a crash. Your total damages, $100,000. That includes medical bills, lost wages, pain and suffering, everything. If you're found to be 20% at fault, you can still recover $80,000. If you're 40% at fault, you can get $60,000. Even if you're 90% at fault, you can still recover $10,000. The key is that no matter how much blame you share, as long as you're not 100% responsible, you can get some recovery. This system recognizes that most crashes aren't black and white. Maybe you were distracted for a second, but the other driver ran a red light. Maybe you were slightly speeding, but the other driver failed to yield. Pure comparative fault allows a jury to divide responsibility fairly and make sure everyone who contributed to your injuries pays their share. But all of that's about to change. Starting on January 1st, 2026, Louisiana is switching to a modified comparative fault system. Under this new system, if you're found to be 51% or more at fault, you recover $0. Even if the other driver was 49% responsible, if you're slightly more to blame, you walk away empty-handed. Let me say that again because it's critical. If your crash happens on or after January 1st, 2026, and you're 51% or more at fault, you get no money for medical bills, no compensation for lost wages, no payment for pain and suffering, nothing. This is a massive shift in the law, and it's going to make winning injury claims much more difficult. Insurance companies are already using this new rule against you. All they have to do is argue you were just slightly more responsible than their driver. And if they can convince a jury, or if their own adjuster believes that, your case is over. Think about how easy it will be for them. You were speeding by 5 miles per hour. The other driver ran a stop sign. They're going to argue your speed made you more responsible. You glanced at your phone for a second. The other driver was tailgating. They'll say your distraction caused the crash. Even if their argument is weak, the threat of losing everything at 51% gives them enormous leverage to lowball you throughout the process or deny your claim completely. So how do insurance companies in court actually decide who's at fault and by how much? Well, they look at all the evidence. Evidence such as police reports, witness statements, physical evidence from the scene like skid marks, vehicle damage, traffic laws and rules of the road, and sometimes expert testimony from accident reconstructionists. The problem is that fault determination isn't always objective. Two people can look at the same evidence and come to different conclusions. That's where insurance companies are going to exploit the new law. They'll argue for a higher percentage of fault on your side to reduce or eliminate what they have to pay altogether. Let's say you were merging onto the highway and another driver was speeding and rear-ended you. Under the current law, a jury might find you 20% at fault for not signaling properly and the other driver 80% at fault for speeding. You'd still recover 80% of your damages. But under the new law, starting in 2026, you can bet the same insurance company will push harder to bump your fault up to 51%. Maybe they'll argue you merged too slowly, or you didn't check your mirror. If they succeed, you get nothing. That's why challenging fault assessments has never been more important. You're going to need strong evidence on your side. Dash cam footage, witness statements, traffic camera videos, anything that shows the other driver's actions were the primary cause of the crash. And you're going to need a lawyer who knows how to fight back against these inflated fault claims. If you've been in a crash and you think you might share some responsibility, here's what you need to do immediately. First, be very careful what you say at the scene and to insurance adjusters. In fact, you shouldn't talk to the adjuster without speaking to an attorney first. But if you do not admit fault. Even innocent comments like, "I didn't see the car," Maybe I was going a little fast. Those can be twisted into admissions that increase your percentage of fault. Look, stick to the facts. Tell the police what happened without speculating about who's responsible. Second, gather as much evidence as you can right away. Take photos of the vehicle, the road conditions, traffic signs, anything else that helps tell the story of what happened. Get contact information for witnesses. If there are nearby businesses or homes, see if they have cameras. Note that. Try to obtain it. The more evidence you have, the harder it will be for the insurance company to shift blame onto you. Third, don't give a recorded statement to the other driver's insurance company without talking to a lawyer first. Adjusters are trained to ask leading questions designed to get you to accept more responsibility than you probably deserve. Once it's recorded, those statements are going to be hard to take back. Fourth, you should consult with an experienced personal injury attorney as soon as possible. An experienced injury attorney knows how to investigate crashes, knows how to challenge fault determinations, and knows how to negotiate with insurance companies that are trying to minimize your claim. Under this new modified comparative fault law, having a lawyer becomes even more critical because the consequences of being labeled 51% at fault are so severe. Finally, understand the timing. If your crash happened before January 1st, 2026, pure comparative fault rules are going to apply. You can still recover even if you're mostly at fault. But if your crash happens on or after January 1st, 2026, you're under the new modified comparative fault system, and crossing that 51% threshold means you get nothing. Don't wait to file your claim or consult an attorney. The sooner you can start building your case, the better position you'll be to fight inflated fault claims. Some folks think the new law sounds fair. After all, if you're mostly responsible, why should you recover anything? But here's the reality. This law is designed to help insurance companies, not injured folks like you. It gives insurance companies a powerful tool to deny legitimate claims by arguing we're just slightly more at fault than the other driver. Even when they don't win that argument, it slows everything down. They'll dig deeper, fight harder, drag out the process, hoping you'll give up or settle for less. The new law likely won't reduce lawsuits like supporters claimed. My guess is it will increase lawsuits because more cases will end up in court fighting over exact fault percentages. And here's the worst part. The insurance companies that lobbied for this change are the same ones that are going to use it against you. They're already training their adjusters on how to maximize your fault percentage to avoid paying you just compensation. If you've been in a crash and worried about being more than 51% at fault, I'm injury attorney Lloyd Bourgeois. Call me and my team today at 504-882-9867 for your free case evaluation. We'll review your case, explain how the current or new law applies to your situation, and fight to make sure you get every dollar you deserve. Remember, when you want to win, you gotta give them the L. And if you found this video helpful, hit that subscribe button and check out this next video.